bail, it's a topic we've talked about quite a bit on this program, and now California has become the first state to totally scrap it. Plus, several other states, including New Jersey, have dramatically scaled it back. Well, a study's now out by the New York Civil Liberties Union. It sheds a whole lot of information on this issue. Now, it took a look at 8 counties, all north of New York City, and it contains, at least for me, some eye-popping numbers. They looked at the years 2010 through 2014, and 64% of the misdemeanor cases had bail set. That's 113,000 people. Again, we're talking about 8 counties north of New York. Now, this video from the NYCLU provides some more details.
80% of people who had a bail set were forced to spend at least a night in jail because they couldn't pay. 40% were in custody for 1 week or more. 60% were charged with minor offenses or less. That means misdemeanors like petty larceny or even violations like disorderly conduct. 45% of pretrial detainees were black, and black pretrial detainees were 2 times more likely to stay overnight than white pretrial detainees.
Now, in addition to the racial disparity mentioned in the video, there's also wide variations among the counties. Now, take a look at the numbers from Westchester County, which are well above averages. 57% of the detainees in that county, they remained in custody for a week or more. Now, in contrast, take a look at Orange County. Same thing, except just 20%. Also in Westchester, a whopping 92% of the people who had bail set were not able to post it. So for more, I sat down with Westchester County District Attorney Anthony Scarpino. Even as the head prosecutor who uses bail as a tool, you'll agree, and I think it sounds like the majority of DAs agree in the state of New York, that the bail system isn't working the way it's currently constituted and we need changes. Is that fair?
Well, you know, there's the human involvement in regards to it. The actual current legislation is very flexible. It's very progressive. It allows for bail under releasing people on their own recognizance to 9 different forms of secured and unsecured bail, as well as remanding someone into the custody of correctional facilities. So the legislation itself is not a problem. What appears to be the situation is that there are certain situations that are occurring in mainly New York City that have caused unfortunate incidents where young people are being held in custody for cases, minor, non-violent misdemeanors, in which they probably would not receive jail time at a disposition, but while the matter is pending, they were there. They were held in custody in a place like Rikers, which is filled to capacity, in which people seem to get lost in the system. You're trying to correct that problem by creating legislation that's going to affect the entire state, where we're not having that problem, for instance, in Westchester County.
You saw the same numbers, though, that I did from that NYCLU report that came out. And they didn't look at the city. They looked at 8 counties north of the city, including Westchester, which had the biggest population representation in there. And they looked between years 2010 and 2014. So I grant you, it's a few years removed. But of 178,000 people who are held in custody pre-trial for misdemeanors now, of those, more than 113,000, or about 2/3 of them, had money bail set. Now, the way I understand it, correct me if I'm wrong, is I'm saying your office, but any DA's office, can request bail or not.
Correct.
And it's the discretion of the judge whether or not to take that recommendation or to go on his or her own and assign bail regardless. Is that working?
So, you know, what I have done in Westchester has been that I have required our prosecutors in these nonviolent situations, these minor misdemeanors, where there are no exacerbating factors, to assume and request that the individuals be released on their own. Now, I know the statistics you're talking about,
right,
but they were 3 or 4 years old, number one. And number two, our situation is not the same as it was back then. So I don't, you know, I felt that we wanted to be very progressive in regards to it and continually reevaluate what's going on. But the fact of the matter is, I think that our steps that we're taking back in January, ahead of this potential legislation, which is nowhere near, you know, coming to fruition, was the appropriate thing to do early on to be progressive with it.
So you're right. These numbers are old, but in these numbers they showed for the same person who's detained for the same misdemeanor charge, 60% of them, roughly, I think it was 57% in Westchester, were likely to have bail set and they'd be detained versus like 20% in Orange County. As a guess here, would you say if we looked in those numbers for 2018, those numbers would be way down?
I think that, yes, I think that you will see a difference in those numbers. I remember, I was a city judge in Mount Vernon.
Yeah.
And back then, in the 80s, we would set bail $250, $500 on matters, and that was pretty routine. And the recommendations from the district attorney's office was for bail. Now, we're not requesting that. And when the district attorney doesn't request bail, that's a pretty strong signal to the judges that this is what we think is appropriate. And we have, I think that we've had some success in that regard.
See, you've seen this from all sides, from behind the bench, and obviously being a prosecutor and running an office. But it blew me away, and maybe it shouldn't, but I'll be honest, it did, where somebody sets bail for $250, and even with a bondsman, you don't have to come up with the whole number. People can be sitting in there for 5-6 days here because they can't come up with the scratch. I was blown away at how many thousands of people that found themselves in those situations. And as a consequence, they may lose their job, they may lose, a place to stay. It's amazing the domino from something as simple as a misdemeanor carrying $250, how that's a real problem for people not only on the edge, but all the unintended consequences that happen as a result of it. You saw this firsthand?
Yes, and more than that, it's horrific to think that they may have been in custody for $250 or $500, when at the end of the case, the district attorney's office, if he pled guilty, would not going to be requesting jail time. So during the entire process, now of course they're presumed innocent.
Yep.
And during the entire process, they were in custody, even though nobody was ever going to be asking for jail time at the end. The whole reason to set bail has always been to try to ensure their return. The only time people tend not to come back is if they're going to be losing their freedom. And if it's made clear that the disposition in this case, we're offering probation or a conditional discharge or a fine, that's going to be the situation. There's no reason for them not to come back.
You heard what Governor Cuomo said and how he wants to make this a centerpiece of reform. If they got rid of bail outright for all misdemeanors, are you comfortable with that, or do you think you still need it for certain cases?
No, I do think you need it for certain cases. I mean, what we have outlined is that there are certain individuals, even for misdemeanors, that have a long history of not appearing and warrants having to be issued for them. There are also violent misdemeanors, domestic violence, sexual abuse types of charges, things of that nature. These are not all, non-violent types of cases.
Would you treat somebody different if they had a rap sheet from before where they had committed felonies, but in this instance they were cited for a misdemeanor? Does if they have a jacket, should that mitigate the treatment that they get or the bail that's requested?
Under the present and under the current legislation that we have, it's always been a factor what the prior criminal history is, the nature of the crime, whether they've been individuals that have failed to appear in the past, whether they are a threat to the community or a witness or a specific individual, for instance, in domestic violence, whether they fail to obey other court orders. These are all factors that come in. And that's why, the concept of eliminating bail concerns me, because you are always looking for the least restrictive way to ensure a person that's going to come in. If you just have releasing people on their own, ROR, release on their own recognizance, or remand, jail, you're a carpenter that has a toolbox that's missing some important tools. And if you are concerned about this individual that you might have in the past on a more serious case considered giving bail to, but you don't have that option, it's either ROR or remand, you're going to go to the remand status, which is not the least restrictive. So I don't like losing the tool. They are taking away, by eliminating bail for some felonies also, they're taking a tool away from the judges. They're not taking a tool away from me.
District Attorney, I wish you the best, and also I want to thank you for talking about this issue. I know you're invested in it along with the other DAs in the state here. Let's hope some real changes happen with the bail system. Thank you so much.
Good seeing you again.
When we come back, I'm going to sit down with a friend of the program, Mayor Bartlett. He used to be a prosecutor and now he's a defense attorney, so he's seen both sides to this. He'll join us to take a closer look at the numbers we talked about and also Who are these people most impacted? Stay with us.